Hi, hello. I'm Dr. K. Pungudi, Assistant Professor in Department of Commerce. Now we are going to discuss about the warranty. In above slide, we have discussed about the condition in sale of goods. Now we are going to discuss about the warranties in sale of goods. A warranty is a secondary or a subsidiary terms in the condition of sale of goods. So it is also one of the most important thing. It is not an essential to the main purpose of the contract, but it is a supportive the main agreement of a condition over here. If it is breached, the contract does not end. So warranty is a minor promise about the goods. So that is known as warranty. The legally a warranty is termed in a contract which is a collateral to the main purpose, breach of which gives only the rights to claim the damages, not a rejection. If any damages occurs, we can claim for that, not a rejection over here. Next thing is that nature of warranty. In this nature of warranty, it is a secondary obligation and it not have fundamentals to a contract, can exist independently and does not affect the ownership or a main purpose over here. The next thing is type of warranties over here. What are the different types of warranties we are having, how it is working over here. So first thing is express warranty. In this express warranty, it is clearly stated by the seller in words or a written. Example, this product has 1 year service warranty, engine warranty for a 6 months. So it has a written or a word or a written communication given for that warranty period. The next thing is key feature of this is that clearly mentioned in the contract, legally binded with the promise and specific product or services. So we will give a clear mention over that. This is only for a 6 months, only for a 1 year warranty. So we have clearly mentioned over that, and it has a legal binding promise over it. So if within a 6 months if anything occurs, means automatically the warranty will be and the guarantee will be given over that. So next thing is the specific to that product or a services. Which product they have buy over there only we will give a service for that, not for another thing. So that is a specific to a product or a services. Next thing is implied contract. There is a no written but automatically included by the law as it is in the Sale of Goods Act 1930. Next thing is the warranty of quiet possession. Here the warranty of quiet possession means buyer should enjoy the goods peacefully. Example, if someone later claims ownership of a purchased goods, the seller is liable. So that is a enjoying their goods. Next thing is warranty against embarrassment. Here means the good must be free for a legal charges like loan, mortgages, etc. Example, buying a car that is under the bank loan, that is known as breach. So that is a warranty against embarrassment. Next thing is warranty of a quality or a fitness. In some cases, if the condition is not applicable, it may become warranty. So the minor defects in a product that does not affect the usages over here. The next thing is warranty in sale by sample. Here the goods must be reasonably match the sample quality, that is minor variations is equal to warranty issue over here. The next thing is that effects of breach of warranty is also occur over here. Buyer can claim the damages, that is a compensation over here, and they can reduce their price and have a continuous contract over there. The buyer cannot, what the buyer cannot do, the buyer can do, they can claim the damages and reduce the price and continue the contract. That is the compensation given by the warranty. The next thing, buyer cannot be done. So what are the things the buyer should not done over here? Cancel the contract and reject the goods. When the condition becomes warranty, here there is a condition become warranty in certain cases. The waiver by buying, the buyer accept the defect goods knowingly. So that is known as conditions become a warranty. For example, if any small damages over there, they will give the reducing price and they can get over it. So it is knowingly done by the buyer. Afterwards only the seller is selling the goods. That is known as waiver by a buyer. Next thing is acceptance of a goods. Buyer buy the goods after discovering the defects. So the same thing over here. If any defects appears, they will knowingly know that there is a defect over there. That product only we are going to buy over here. That is known as acceptance of a goods. Next thing is contract separation not possible. Here when the contract cannot be divided, so that is known as contract separation not possible. The next thing is that we have to remember the key points in the warranties are: warranty is a minor term in the contract of sale. It supports the main contract, that is conditions. Breach gives only the damages, not for a rejection. Defines under the Acts 1930, mostly related to the quality, service and usages over here. Then that is a thing. I hope you all understand about the what is sale of goods, warranty, implied, expressed and different kinds of warranties over here. So it is a minor point taking over inside a contract of goods, not a major point. So thank you. I hope you all understand about the what is warranty in sale of goods. Thank you.